Good morning. Today is January 16th, 2019, and we're here to discuss a proposal, ZDO 271. First off, I'll call the meeting to order, and see, when did we do the Pledge of Allegiance? We probably don't do that. No. Let's start off with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Before we begin, I invite, there it is, rise. Today we will be considering ZDO 271, which is a legislative text amendment to Clackamas County Zoning and Development Ordinance, which proposes to limit the number of licenses permitted for recreational marijuana production and the number of registered grow sites for medical marijuana productions on property zone ag, forest, exclusive farm use, or timber. This amendment also proposes certain non-substantive text amendments to clarify current marijuana related land use regulations. The hearing on ZDO will proceed as follows. ZDO 271. We will first hear a presentation from staff, Glenn Hamburg. Next, I'll open the hearing for public testimony, beginning with public officials. We'll have 5 minutes each. Then representatives from recognized community planning organizations and agencies will have 3 minutes each. Finally, others wishing to testify will have 3 minutes each. The board will then deliberate and either render a decision today or set a time certain to make a decision at a later date. Assisting us in the hearing today is Clerk Kevin Moss, Planning Manager Jennifer Hughes, Planner Glenn Hamburg from the Planning and Zoning Division, and Assistant County Counsel Nate Boderman. If you wish to testify, please fill out one of these green cards out on the table and give it to Kevin. And if you have a prepared written statement, please give a copy to Kevin that we can use to add to our packet. And if possible, you'll see there's quite a crowd here today. If somebody repeats something or says something that you agree, you can raise your hand. And if you feel they've testified adequately, let me know, because we got a lot of people here. And 2 of us have to be somewhere at 12. And at 3 minutes each, it's going to be very tight. If we don't make it, we'll extend it to a time certain. Actually, it's February 6th. But right now, we'll start off with a presentation from Glenn Hamburg.
Good morning. Thank you, Chair, and good morning, Board. Maybe while the screen's coming down, just a quick order of business. I place before you a copy of about just nearly 20 exhibits that have come in since we provided your packets last week. And of note, about the second exhibit in is the only comment that we've received from a CPO so far. Also today we received another written comment that we don't yet have copies of for you, but I'll just summarize to say it's supportive of the proposed amendments. So again, my name is Glenn Hamburg. I'm a planner in the Planning and Zoning Division. ZDO 271, as the chair mentioned, is a proposal to limit the number of licensed growers effectively on properties in the county's natural resource zones. Those are ag, forest, EFU, or TBR, only those 3 zones. The package of amendments would also clarify, but would not substantively change existing rules related to marijuana production and processing for clarity that I'll mention at the end of my presentation. A little bit of background and reminders on some of the terminology that might come up today. It's the state's OLCC that regulates recreational marijuana production, and they license that production on premises. Each license has a different tier, and that tier allows a canopy size of mature marijuana plants. The OLCC issues licenses per tax lot. there is no limit on the number of tax lots that there can be per lot of record or tract. The OLCC estimates that as of November, there are 161 active licenses in all of the county for marijuana production. The OLCC doesn't provide those figures based on zone, so we're not able to determine how many of those are in the subject natural resource zones, but this would include industrial zones, rural residential zones, etc. We also don't know how many of these are actually operating, but those are the number of licenses. Medical marijuana, conversely, is regulated by the OHA, and the terminology for that is a registered grow site for medical marijuana. The OHA, instead of canopy size, regulates the number of plants that are grown and the number of patients per address. The OHA in April found that in Clackamas County, there's just shy of 1,300 registered grow sites for medical marijuana, and about 83% of those are just for one patient. I pulled some figures, photos rather, off the internet of some structures that are in other states, not here in Clackamas County or even in Oregon, but they're nonetheless similar to the facilities that are used for production in the subject zones. So you can see that there's some metal pole barns and some, I'll say, fancier greenhouses. The photo in the top left is important because it could show what we would still consider as outdoor production while nonetheless being in a structure. Outdoor production is defined by the lighting on mature flowering plants. Outdoor production is only lit by sunlight and no artificial lighting, but can nonetheless be in a physical structure. Some quick figures. Staff have gone through all of the marijuana production land use approvals to date for the subject zones, and we estimate that there is about 200 acres of floor area total that could be used for mature, that's flowering plant production, pursuant to the terms of those land use permits. 200 acres total of total floor area just for the flowering plants. Of all that approved area, about 2/3 is in the county's EFU zoning district, and about 60% of it is for outdoor production. But again, outdoor production might still be in a physical structure, just not using artificial lighting on mature flowering plants. This map, I think, is helpful in showing the distribution of where those marijuana production land use approvals are in the county. The square sizes are hard to read, but I think the most important thing to take away from the map might be just that there's not a specific location where these are crowding. They're sort of throughout the county evenly distributed. Of all of those land use approvals that the county has given for production in the subject zones, we've attempted to estimate how many licensed producers could potentially operate under those land use approvals. This is not an exact science because we've never limited the number of licensed producers or registered grow sites before, so therefore we've never collected the information from applicants about it. But based on the square footage that we've approved and some other information that might have been in somebody's application packet, we've estimated that about 40% of the indoor production land use approvals would accommodate only one licensed producer, given the amount of area that was approved, and of outdoor production, about 43%. So the commission has raised concerns that having multiple licensed premises for recreational production or registered grow sites for medical production might be bringing too much on-site activity and development than is appropriate for these natural resource zones. Simply by allowing multiple growers on one site might cause there to be, for example, more buildings, more employees, more traffic, and that might be different than other types of farming activities that are in these zones already. So the board directed the planning division in its long-range planning work program to propose license limitations on recreational production in these natural resource zones. The county's planning commission held a first hearing on this topic on November 26th. And here are two of the significant issues that were discussed then that we can talk about here this morning. One is just, should there be a limit on the number of licensed or registered producers in the natural resource zones? And if so, what should that limitation be and how should it be based? And then also there was discussion about what the effect of new regulations limiting these numbers would be on previously approved or implemented land use approvals. So we can talk about those two significant issues here. First, should there be limits on licenses and registrations? Well, on the one side, these limitations may indeed reduce the level of activity and the intensity of development, as we mentioned. And adopting these restrictions for marijuana production might be appropriate despite it being a farming activity, because marijuana production might be more of an intensive farm use than other types of farming activities. It's something that maybe is grown year-round. If it's grown indoors, you can grow any time of year, and there may just be more structures involved, equipment, employees, etc. And also the limitations would respond to the concerns and complaints that you've received. On the other hand, the scope of other types of farming is not limited. There's no limitation for the production of lavender, for example, or for hemp. This proposal only deals with marijuana. It may not affect existing operations that have been legally established and have not discontinued for more than 12 months. It would require somebody who has an existing operation to potentially need to go through a non-conforming use verification process. And if they wanted to expand or substantively change what they have been sort of grandfathered in to do, to go through an alteration of a non-conforming use process. Also, these limitations may reduce income opportunities for property owners who have looked into leasing out portions of their property to producers. And there may be external factors out there, for example, the oversupply of marijuana already, that might in itself slow the growth of future production in the subject zones. If the board decides to pursue a limitation, another question to ask is, well, on what terms should those limitations apply? Should the limitations apply per tract of land? And just as a reminder, a tract is one or more contiguous lots of record under the same ownership. A limitation per tract would be the most restrictive. And this was the original proposal staff had to the Planning Commission to limit a tract in these three zones to just one licensed producer or registered grower. This is what we noticed for, and again would be the most restrictive, and the board could certainly go back to that, even though the Planning Commission, as I'll explain, ultimately recommended something slightly different. Regulating this by tract would be consistent with how we have drafted other marijuana land use regulations in ZDO section 841. Production already applies per tract, so that would be consistent. On the other hand, the limitation could be avoided simply by having one of the component lots of record in a tract just put it into a separate ownership, putting it into the name of an LLC, for example, and then all of a sudden it would not be considered one tract but separate tracts because of separate ownership. It may be slightly more time-consuming for staff to administer because we would need to verify the ownership of adjacent parcels, but I want to stress this would only be slightly time-consuming, and staff are happy to administer whatever the regulations are that get decided on. Importantly, though, tracts vary in size. You might have one tract that's 5 acres, but you might have another tract that's 100 acres. The limitation of one per tract would, of course, apply equally regardless of the size of that tract. Another option is you could limit licensed premises or registered grow sites per lot of record. An upside is that would be slightly easier for staff to administer because we don't have to check ownership of adjacent properties, but it would not be consistent with how we define opportunities for production based on tract elsewhere in the ZDO. And just like tracts, lots of record vary in size as well. So if you have a limitation of 1 per lot of record, that might be unfair to a property owner who has a specifically large tract, or lot of record rather. Another option is you could establish a limit on the number of licenses per certain acreage. This might be the fairest to owners of large tracts or lots, but it's not really clear what certain acreage that limitation should apply to, and whether there should be the same limits for indoor production and outdoor production, or for recreational or medical. The terminology would not necessarily jive so well, I'll say, with the tract standards that we have in the ZDO. And the Planning Commission considered the thought that, well, if ultimately there's an interest in thinking about how the facilities for marijuana production are sited on a property, if they're required to be dispersed and spaced out, that might have negative impacts, actually. It might encourage property owners to push some of these facilities to areas that end up taking up more natural resource land than if they were consolidated in a closer area. The second significant issue that I mentioned, and I'm only going to discuss it briefly, is what the effects of any amendments that you adopt would be on previously approved or implemented marijuana production land use approvals. So any legally established use, including legally established marijuana production land uses, could continue as non-conforming uses. But it would require potentially somebody to go through the verification and alteration approval process that the county has for all similar types of grandfathered rights. The county land use approval that a property owner may have received may not be enough to establish a non-conforming use right. It may be the case that somebody needs to show they've actually gotten their license from the state as well to have established that right, the grandfather right. And then there's also the question about vested rights. Those are when somebody has not quite fully started up, but has invested a lot into their plan to do it, and then the rule changed. We won't be addressing any specific concerns of that here today. Somebody would need to make an application and show that they have a vested right, but that's how that would be resolved. So considering the concerns of multiple licensed producers and the scale of development and activity that we talked about, while also considering the interests of property owners, the Planning Commission decided to recommend this scheme, that rather than just one licensed premises or registered grow site per tract, regardless of its size, they established this rubric where you could potentially have more if your tract is larger than 20 acres. So a tract that is less than 20 acres under the Planning Commission's recommendation would still just get one. But for every additional 10 acres of area for that tract, you could have an additional licensed premises or registered grow site, but no more than 5, even if your property is 60, 70, or 80 acres. I mentioned there are some non-substantive amendments in this package. These are amendments that would further standardize the provisions related to shared access in the ZDO. We just want the language in one section to be as close to similar language for similar policies in other sections. It would correct references to licensed engineers to match how the state speaks about those. It would change terms like yard depth to setback for consistency. It would clarify the applicability of existing noise standards. It would not change them, but after 2 years of administering the marijuana land use regulations, people have been confused sometimes about how it's read, so we're proposing to clarify it. And finally, it would provide consistency with other sections' formatting and content. So staff's findings and recommendations are to adopt what the Planning Commission has recommended, and staff finds that those amendments comply with all applicable state, regional, and local criteria. And again, the Planning Commission's recommendation is to limit a tract that is less than 20 acres in these natural resource zoning districts to only one licensed premises for marijuana production by the OLCC, or only one marijuana grow site registered by the OHA. However, the Planning Commission's recommendation, as I mentioned, would allow for one additional premises or grow site per 10 acres of tract area above, that should actually read 20 acres, with a limit of 5 total premises and grow sites per tract. And then there would be those non-substantive amendments. Before I conclude, I just wanted to clarify again that the applicable zoning districts are only those 3 in the natural resource zones: ag, forest, EFU, and TBR. The proposal would not restrict marijuana production further in rural residential zones. And the reason behind that is staff believes that the limitations on production in those zones would likely limit the ability for there to be multiple licensed premises or registered grow sites already. Ultimately, though, the notice and scope of this project is only for the limitation in these 3 zones. So considering a limitation in rural residential zones here today would be outside of the scope. Nonetheless, it could be something that the board considers adding to its work program for next year. So with that, I'll conclude my comments and then answer any questions that you have right now. Thank you.
So I just want to clarify, I know this answer, but so I have 6 acres, 1 lot of record. My neighbor has 13, 2 lots of record. Right now, what we're talking about, if we do tracts, he could do 1 license. If we do lots of record, he could do 2.
Correct. And that's presuming that your neighbor's 2 adjacent lots of record are indeed under the same ownership, literally the same people owning each lot.
Yeah. The other thing is that we're talking only about mature plants, flowering plants. They could, so 1 building for flowering plants, there could be 5 buildings for starts and processing and all that other stuff that could accompany that 1 big building.
That's a good question. So this proposal would only limit the number of licensed premises, as that term is defined by the state. And a licensed premises, depending on the tier of that license holder, would afford a certain canopy size area, canopy of mature flowering plants. A licensed premises is not restricted in the total operational area, the number of structures, the number of square feet for support uses like storage, drying, trimming, and curing, only the canopy size of mature flowering plants. So this proposal would not directly limit the number of buildings or their size. It would only indirectly limit the effective mature plant canopy area pursuant to that license holder's tier.
Okay, one more question. Medical marijuana, a lot of medical marijuanas are converting to recreational marijuana. So a medical marijuana grower wants to convert to a recreational marijuana, but the rules are different. How would that apply? The changes in the rule apply to that medical marijuana grow?
I wouldn't be fully up to speed on how that process works at the state level. It's my understanding that now, under current rules, a recreational producer already might be able to produce some plants for medical production. But in this proposal, the limitation would be either 1 licensed premises for recreational production or 1 registered grow site for medical. There could not be both.
Okay. All right. Paul.
Yeah, question. We're here today probably, as you outlined, the concern about the intensity on a particular activity, and looking at the Planning Commission recommendation, and I'll just use the example of a tract that's 50-plus acres. That would very likely have, in some cases, just 1 access point, right, from a road. And is there any, there's probably no requirement under this scenario for how that access to other units are handled on the tract itself, but more, my concern would be, on EFU typically, regardless of whatever the activity is there any, do we have any really control to make sure that access points or intensity, safety, any activity, whether it's line of sight, safety issues, is there any controls that we currently have in place when it talks about access? Because this is due to the intensity. That's why we're here today, is the concern of intensity on a site.
Do you want to answer that one?
So as a general rule in the EFU district, if you're proposing a farm use, then under the zoning ordinance, there's no control over the issues that you've identified. And as a general premise, we're prohibited from regulating farm uses beyond what the state statute stipulates. And it's the whole right to farm and all of that. Now, the county has roadway standards that apply to access points generally. So if somebody's going to put a new driveway in, there are still standards regarding where that goes in terms of site distance. I am not, those are administered through the engineering division of DTD, so I'm not up on all of those specifics, but there's some ability. We wouldn't be denying access, but for instance, they don't automatically get 5 access points, for example. And we might be able to have some preference as to where their one access goes to consider those things. But it's not looking at traffic volumes in that context. It would be more of a safety provision.
Okay, thank you.
Okay. All right. Yes, Commissioner Fisher.
Oh, thanks. I may have to ask more questions later after we hear testimony, but I just have a few. So you stated that market forces could reduce some of the activities, but based on that we have an oversupply and the price is going down. And so I don't know if you can answer this question, so I would like you to suggest who can answer this question. But if we have an oversupply, we also have just a handful of states that have legalized marijuana. So the oversupply can go into the black market, and I'm wanting to weigh the economic, putting that into the equation of the value of the black market that increases the criminality in this area.
Yeah, I'm certainly no expert on that topic. My hunch tells me contacting a law enforcement agency or the OLCC might be the best start.
Have they talked about this issue at the state level?
I think the answer to that is yes. I mean, the planning department is not participating in the sort of law enforcement conversations. My general understanding is there have been concerns raised by the U.S. Attorney regarding this question of leakage. And I think there are movements afoot at the state level to do something, but what that response ultimately looks like, we don't know at this point.
Okay, and then I have some more questions. What do other jurisdictions do in regards to this kind of zoning? And I know we have, we're sort of limited as we look at Oregon because we have a few areas that are like Clackamas County. I mean, I don't think there's any place like Clackamas County, but what about in Washington, in Colorado, other states that have legalized marijuana? What do they do in regards to this?
Yeah, maybe if you want to ask your next question, I think I have an answer to that in some information that was given to the Planning Commission that I can look at.
Okay. Next questions. Oh, I was curious. You talked about that there's a process for marijuana producers that are grandfathered in, but what is that process?
Yeah, so when people say a grandfather right, they're generally referring to a non-conforming use right. And a legal non-conforming use is somebody's land use that was legally established at some point before the rules changed and has continued through that change and has not ceased since that change for a period of 12 months or more. That land user could continue doing what they're doing under state law, just like any other legal non-conforming land use. But there are circumstances in which that person would need to prove it through a verification of a non-conforming use process. That's a land use decision that somebody would submit an application for, and the Planning and Zoning Division would issue a decision. And then similar to that would be an alteration of a non-conforming use. If they wanted to change something about their grandfathered land use right, they would need to lodge an application for that to the Planning and Zoning Division.
Okay, so they have a process to go through.
Yeah.
It's a short answer to that. Let me, and while you're looking for that, I should know the answer to this, and I just don't. How many acres are in a rural residential zone?
You mean how many acres total in the county, or how many
No,
acres?
what creates
Per-
that zone?
Okay, so for rural residential, we have multiple categories. In the context of marijuana, there are only 2 rural residential zones that permit marijuana production at a commercial level, as opposed to anybody can grow the 4 plants on their property under state law. And those are our RFF5 zone, which is
5
5
acres.
acre, and our FF10, which is 10 acre. It's important to note, though, that just because the zone is a 5 acre or a 10 acre doesn't mean that every lot in those zones is that size, because some of them predate the zoning, or they predate the current zoning. And there's some flexibility in those zones to create, under certain circumstances, lots that are as small as 2 acres.
Okay.
The actual standards, though, for marijuana production in those zones do require a minimum lot size, so not every lot in those zones is permitted to have commercial marijuana production. And that minimum lot size is either 2 acres or 5 acres, and it's based upon the size of the parcels around them. So we're looking at kind of what is the neighborhood like. So yes, it's a little bit complicated.
That is complicated. So when you gave the background, I think one of the first slides, you said there are 161 approved licenses for recreational and almost 1,300 for medical. Did that include the rural residential zones as well? So that's countywide. Do you have a differentiation of what is in rural residential and what is not? You said you qualified that. Do you have any idea? Is it
No,
less
because
than half? Is it a third? Is it 20%? Is it?
we don't, because the county's not really in the loop on the licensing process at the state. They go through a land use approval process, if there is one with the county, and then they go and they get their license. And so the state publishes how many licenses they've given out and to whom, but they don't say where, and they don't report what zones of the county jurisdictions those would fall in. So those would include industrial zones, rural residential zones, and natural resource zones, all of the areas.
Okay.
But to answer your other question about other jurisdictions, as of November, neither Washington County, Multnomah County, or Marion County had any limitations on licensed producers. However, Marion County does not allow recreational marijuana production. They opted out. Washington County allows both indoor and outdoor production in its natural resource zones, real similar to Clackamas County. Multnomah County allows both in its farm zones, but just outdoor production in its forest zones. I heard that Deschutes County was considering a license limitation, but I haven't heard if they've actually adopted those.
And other states?
Yeah, I'm not even familiar with how licensing works in other states.
Okay, Ken.
I'll pass for the moment.
Paul.
Well, I just want, on that very note, I just want to if I understand correctly, and correct me if I'm wrong, anyone, and that is that, in my understanding, there's probably more licenses in Clackamas County than there probably are production licenses in Clackamas County, granted, than there are in Multnomah County and Washington County combined easily. Hence, that's why we're here. I just want to make that assumption and statement.
Okay.
I don't know the exact statistics, but we're near the top. We're not the top statewide, but we're near the top.
All right, so we're now going to open the public portion of this hearing and are there any elected officials? No? How about CPO reps? Okay, so what was your name? Okay, well, I may call you twice, but go ahead and come up. You have 3 minutes. It really doesn't make a difference, though, does it? So go ahead and come up anyway. And let's have Patrick Pooler come up also. And please limit your time to 3 minutes. And there's a clock up on the wall and also in front of you. Go ahead.
Hi, I'm Leah. I'm from Colton. I'm from Colton. Is that better?
What is your last name?
Rollier. I've been a member of the Colton CPO for going on 20 years. Been a member of CCI. I've kind of been involved with our county and our government and our land use operations for a number of years. Live on rural land, have rural neighbors as well as rural residential neighbors, take into account the concerns of the jurisdiction that live within our CPO district, which is a very large voting block with a variety, just like the rest of the county, of living and interests. We have had some concerns with the new laws of marijuana growth and production. We support the actual law that people should be allowed to grow their marijuana and have business. We do have concerns, however, about how that's being governed in terms of how much is on a lot, how large is the lot, how much protection does the lot have from other neighbors, and how much protection do the neighbors have from those productions. So this is a good start for trying to have some kind of control over what we do with our resource land, which is the most valuable lands we have in this state. One of the things I like about this concept is that, being an Oregonian, I very much support the idea that we shouldn't rely on other states or other people's input. We are kind of pioneer people with pioneering spirits and ideas, and I think should indeed make our own laws about our own land use, as we have now for many, many, many decades, and I think has served us well. I think we wish to preserve our waters and our lands and our air and the ability for our people to live well in the zonings that we have created for the reasons we've created them. So I support land use zoning and the purposes of what zoning does for us as a community, and our community being our particular county, but also a representative of our state. So I can have many, many concerns about this and many of the things you brought up I would like to address. I would like to add some written material to the docket, although I haven't prepared it at this moment, but in order to enhance our concerns, I'd like to have the record held open so that I might be able to get some written material to you. So I realize that's not terribly specific, but we have a lot of concerns about the growth of this and how it's managed.
Okay, thank you.
Thank you.
Go ahead.
I'm Patrick Pooler. I'm the owner of Heroes of Farm. I have multiple properties in Clackamas County, and I have already been directly affected by local law changes in terms of county. We got zoned out for TBR Ag, so then we started searching for another piece of property to do extraction. That piece of property we found on Highway 26, Richardson's Nursery, which was 77 acres. It was 10 legal tax lots. We did all of the land use with the county, also with land use attorneys, and then we bought that piece of property for over $1 million. And within 6 weeks of closing on that piece of property, the county zoned us out again on EFU for extraction. It then left us again searching as a company into Estacada, where we purchased Mike Park's building in the Estacada Industrial Park, because that is the only place we are allowed to legally extract. So I actually own about 300 acres in Clackamas County. And the thing from the last meeting that I hear in this is a cannabis issue, but the primary thing that was spoke about was hemp. This goes beyond cannabis and the uses of what we're doing. We're already being heavily regulated by the OLCC, and you know, the market is already shaking itself out. And what we're talking about today is already being addressed by the state. In July, the olive licensing has been shut off by the state, and the state is right now in session trying to figure out what we're going to do collectively. I think it's premature of the county to try to step in. You know, there is an overproduction problem, absolutely. But if you look at that overproduction problem, what cannabis is inside of the system, most likely would probably need to be disposed of because there's probably not good cannabis to be sold, and that's why it's sitting in a system. Just like if you were to look at the alcohol industry, how much overage of alcohol is in our system right now? Do we have a problem with overproducing wine? So I think from a state level, we need to give our state regulators the time to actually correct this. In terms of how this would affect me personally, it would affect the future endeavors that I have worked on very hard with my lawyers, with the county, and my overall production in terms of a company to be able to continue to facilitate, my business and something that I believe and work hard for. And again, a lot of the smell, a lot of these things that are coming from, the last meeting, a lot of it was in Malala by Skydive, Oregon, and I understand that's a hemp farm. That has nothing to do with cannabis. So I just think from one of the things that we need to put into perspective is, we're talking about one thing, but we're actually talking about multiple issues that as a state, we need to continue to figure out. And I just think that it's a premature session to have as a county. And I think that, again, we just need to let the state figure this out and give them time. And if the county doesn't like those decisions after these sessions have happened, then I think that it needs to be addressed at that point. Thank you.
Thank you. Yes, Paul?
Yeah, just a quick comment, and that is I hear what Mr. Pooler said, and I think I agree that, frankly, it's the state that needs to work on how to limit the production, the overproduction. That's not our role, and that's not our goal. Our goal is the intensity and activity on our county and our rural areas. So I just want to make that distinction.
I think we should limit our comments on this until we get through all these folks, because we have to get out of here at 11:30, and some people may only have this opportunity to attend this meeting, so thanks. So Amanda Leskew, sorry if I mispronounced that, and Wade Holman.
Good morning. My name is Amanda Levesque. I'm not only a landowner in Clackamas County, but I work here as well. I am the executive assistant at Heroes of the Farm. I'm really excited about this industry, and I think that we have to trust in the processes that the OLCC has put in place. My concerns lie in the fact that my family, my job, my livelihood, and the passing of this negatively would impact all of the things that I have worked so hard for so many years. I know we can do better than this, and I know we can be better than this. While I understand the county concerns, as well as the citizen concerns within the county, I fiercely oppose ZDO 271. I believe this is a misguided answer, trying to control an emerging industry that is already incredibly scrutinized. The OLCC has already put a pause on licensing, is continuing to find solutions to address the concerns of the people of Oregon, and I support landowners' rights, and I see this as government overreach. Let's not get ahead of ourselves with ZDO 271. Thank you.
Thank you. Go ahead.
My name is Wade Holman. I'm a gardener at Heroes of the Farm and work in Clackamas County. I oppose ZDO 271. It negatively impacts land restrictions on local cannabis farms that could inhibit the growth of an industry that is already highly competitive, and it would negatively affect my employment and the livelihood of my family. So I strongly oppose ZDO 271.
Great. Thank you both for being short. Deanne Colum, and Curtis Tyler.
My name is Deanne McCollum, and I'm here as a Clackamas County resident and also as an employee in Clackamas County. ZDO 271 could affect where I work and raise my family. This would not support the many efforts and great strides I have taken to be where I am. The cannabis industry is just starting to gain its structure in the right direction. We're paving the ground for all of us and setting expectations as our farming families have with other ag crops in history. Our goals should be to support each other while we create more relationships and jobs, not to devalue what we have all worked so hard to achieve. So I oppose the ordinance ZDO 271. Thank you.
Thank you. Go
My
ahead.
name is Curtis Tyler. I'm opposed to ZDO 271. I'm a full-time employee at Heroes of the Farm. I've been there for 5 years. I came from the world of education. I was a band director, a middle school band director, and a high school band director for 8 years. This will greatly affect my financial life, my house, my mortgage, my wife, my dog. I moved here for Clackamas County in 2002, before the cannabis boom. I love Clackamas County. I've worked at Timberline Lodge. I always get all 3 passes to Skibold, Timberline, Meadows every year. My money I make goes back into the county. And I want the county to allow me to continue to do that. Thank you.
Thank you. Jeremy McCollum and Benjamin Daniel.
Yes, sir. My name is Jeremy McCollum. I live in Clackamas County and work in Clackamas County. I oppose ZDO 271. It will highly impact my job and my family. So I oppose 271.
My name is Benjamin Daniel. I am the Director of Farm Operations at Heroes of the Farm. I am here in opposition of ZDO 271 as it can and will directly impact my employment as well as my staff's, which is a majority of these folks sitting back here with us today. I'm originally from New Hampshire. I graduated with a degree of communications from Green Mountain College in Pulteney, Vermont. From there, I spent almost a decade in the service industry, focusing in customer appreciation. I've lived in places such as Missoula, Montana, Steamboat Springs, Colorado, Bismarck, North Dakota, and most recently I'm a resident of Sandy, Oregon here in Clackamas County for the past 3 years. And I agree with Sonia Fisher when she says Clackamas County is one of its own. I get to look out and see Mount Hood out of my kitchen window every morning as I make my cup of coffee prepared for work. Couldn't ask for much more. My girlfriend, who is currently attending Lewis and Clark Law School, and I rent an apartment in downtown Sandy, shop and eat locally, participate in Heroes of the Farm community outreach. We do road cleanups with our local Furwood CPO. And this summer, we actually did our first honeybee hive on the farm with plans to expand it to 5 hives this summer. It's kind of fun and exciting, different from cannabis. We have shared values in this community, and we plan to spend the foreseeable future here. As our company, we are fortunate to have within our boundaries one of the leading cannabis farms in the state. Heroes of the Farm has developed infrastructure, grown exponentially in the last few years, and become one of the better corporate citizens in our area. And we are very proud of this accomplishment and plan to continue that forward. I'd like to read how ZDO 271 would affect Heroes of the Farm. Heroes of the Farm has spent over $2 million in Clackamas County developing cannabis and hemp production facilities, paying taxes, purchasing real estate, creating infrastructure, and payroll spending. ZDO 271 would mainly affect Heroes of the Farm property holdings and boring at the old location of Richardson's Nursery, as Pat was talking about prior. The property currently has 6 OLC production licenses pending. Additionally, the property has already approved through Clackamas County and the state of Oregon for hemp production and processing. Designation is put into jeopardy by the potential changes of 271. Because the Richardson's property is composed entirely of adjacent tax lots under common ownership within a single tract, 271 would mandate that only a single license be rewarded to the entire tract. Under the current laws, all the licenses currently awarded and in progress would be viable. Heroes of the Farm have undertaken burden to develop this land, and we have thus far purchased the entire tract, paid $22,000 for an aerial survey, engaged in processing OLCC licenses for each tax lot, hired a land use attorney to process lot line adjustments, established addresses for each tax lot, created legal easements, installed over 3,000 feet of compliant roads, brought water utilities to each lot, had perk tests complete for septic, spent 2 years working with Clackamas County to become compliant with all existing rules and regulations. Again, my name is Benjamin Daniel, and I am opposing ZDO 271. Thank you.
Thank you.
Thanks.
Garrick Lotta and anybody got ideas what that is? McIntosh. So, McIntosh. Yeah, I can't read the first name, so.
Good morning, Commissioners. My name is Garrick Latta. I live in Boring, Oregon on Kelso Road, where we have a Tier 2 production facility. I was involved in June through 2015 through December of 2015 on the Clackamas County Marijuana Task Force. I helped the county commissioners and the planning commission come up with all the current rules and regulations. We do have a current problem with overproduction, and you know, I'm okay with some changes that you guys want to make to the current ZDO. The one problem I have is with people that have been, you know, working based off the premises with the rules and regulations that we laid out. That you guys laid out, you know, at the end of 2015. You know, I just think there needs to be some proper structure for grandfathering in for people that have been working diligently over the last 3 years with the rules that have been in place. Notice that you guys were going to talk about the noise ordinance. You know, I currently live on a property that's surrounded by a nursery. They have a pumping station 10 feet off of our property border that puts out about 150 decibels, and we're limited to 50. I think that needs to be addressed in the EFU zoning for cannabis production. I don't think that's a very fair comparison. As well as when we did this, the processing that you guys allowed for the EFU zoning, that all got transferred to industrial zoning. There's a basic simple process using ice and water. I think that that should be allowed in EFU, ag forest, and timber zonings, and that could help with some of the overproduction where the producers could do their own extracting rather than having to rely on other processors in industrial zoning. That's all I have. Thank you.
Thank you.
I'm Donovan McIntosh. I've been in this industry for 12 years now. I've watched it flourish. I just want to continue to watch it grow in the right direction instead of seeing everyone's hard work that they've put decades into, just like I have, watch it actually go somewhere in the proper direction instead of all being thrown away just because a bill says so. Thank you. That's all I have.
All right, thank you. Al Nose and Brad Troutner. Thank you for keeping it short.
Mine won't be very short, sir. 3 minutes. Want to go first, bud?
Go ahead.
There you go.
Sure.
My name is Al Knotts. I live in Clackamas County for 72 years. My grandfather and my father were both farmers. And most of that land right now is under housing. And the state of Oregon and Clackamas County are encouraging citizens to conserve our natural resources, and yet the state and the county and these marijuana facilities to allow them to use up our electricity and water and destroy our prime farmland. There is a 300,000 square foot marijuana grow building facility on Bernards Road. It is on 40 acres. Truckload after truckload of gravel, cement are destroying our farmland. On 40 acres of farmland, Deschutes County only allows 10,000 square feet of grow site. They also do a follow-up inspection every other year on these sites after they are established. Clackamas County should do the same. And also, Deschutes County allows no outdoor grow sites. This is why I think you should limit the amount of grow sites on the property from further destruction of our farmland. This picture I gave you right here, the reason I gave you this picture, my wife and I are coming back from church and we saw this snow-capped foothills of Mount Hood and glowing in the background and the open farmland. We say to ourselves, what a privilege it is to live in our county, and we wanted to share this with you. This picture was taken 1 mile away from a 600,000 square foot grow site just approved by Clackamas County. Thank you.
Thank you. Go ahead.
Hi, thank you for having us here. My name is Brad Troutner. My family and I created a clean and quiet, beautifully organized, responsibly designed, multi-licensed craft cannabis production farm in Borean, which currently provides a place of operation for 25 different small companies. This place has created hundreds of jobs directly. It is so well designed and operated that the OLCC Director of Licensing has asked me to join their Rules Advisory Committee to help solve multi-licensed facility issues. Responsible cannabis farming should be treated the same as any other farm crop, just as House Bill 3400 intended. And it should not be limited on EFU farmland specifically. It should be treated no different than growing or processing crops to make beer, wine, and other alcohol, even though alcohol kills 3 million people a year and cannabis kills no one. First off, I would like to address the odor issue that seems to be of common concern. When it comes to indoor production, there is zero odor coming from these buildings. They maintain negative air pressure, and it's scrubbed through carbon filters. On our farm, the county has inspected each and every building and found that we are 100% compliant. However, we do have 8 acres of hemp growing in the upper field, which is the exact same plant, but federally legal because it does not produce THC. Hemp produces that same wonderful fragrance in the summer months. So anyone to blame an indoor facility for the odor of a hemp crop is just wrong. And limiting indoor facilities will only cause the expansion of outdoor hemp. Secondly, I'd like to compare our farm to the dozens of huge commercial fruit and tree farms in our area that surround us. Collectively, they have thousands of workers and vehicles with 24-hour traffic, lights, dust, odors, and commercial buildings galore. But no one is trying to shut them down. No one is trying to limit the number of production and processing buildings on those farms. No one is complaining about their traffic or the number of people who work there. There are many similarities between those farms and ours, but here's a few differences. We use 0 pesticides and herbicides on any of our indoor or outdoor crops. Our irrigation runoff is very clean and does not negatively impact the local streams at all. We use very little water comparatively and only use drip irrigation in the fields. Overall, we are better to the environment and the surrounding farms than the surrounding farms, and we are more responsible stewards of the land, in my opinion. Most cannabis companies are barely surviving these days, but our farm gives them hope, and it gives them a better chance of not only surviving, but being successful. It gives them a place to grow that is truly affordable, because they're on a farm in an ag building and not in an industrial warehouse in the city paying 10 times more for rent and other taxes and fees. Since a single cannabis company can only have up to 10,000 square feet of mature plant canopy, I believe that limiting the number of indoor growers on a dedicated EFU farm like ours would be a bad idea and does not help the industry to survive. I've been told by the planning division that our 60 cannabis ag buildings are grandfathered in regardless of any future changes. I hope this is indeed the case. We have way too much invested to lose any rights or to let our specially designed buildings become restricted from cannabis farming in the future. Our farm provides a very safe, organized, and consolidated place for craft cannabis producers to have a home and to be successful. It should be recognized as a model for all counties and all states during the nationwide legalization. Thank you.
Thank you. Jason Beaver and Rebecca Boyle. And maybe Jason can sing a song for us. Welcome.
Good morning, and thank you for having us. My name is Jason Beaver. I live here in Clackamas County, and I work in Clackamas County. I am a compliance contractor with the cannabis industry, and in reviewing ZDO 271, I saw a lot of parallels of what's going on at the state level right now. I spoke to many people that I've worked with. I've helped process over 60 licenses and worked on compliance projects throughout the state and most of the counties in which cannabis production is legal. And the OLCC is aware of this. They weren't aware of ZDO 271, though. To everybody that I spoke to at the OLCC, nobody knew what anything was about it. When I spoke with Glenn this morning, it's because there's been no conversation with the OLCC about ZDO 271 between Clackamas County. They're already handling this. They're aware of the cannabis condominiums, of the multiple licenses within a single tax lot that are under non-common ownerships that are creating some of the problems that led to the work group that led to ZDO 271 and led to all of us sitting here today. The truth is, this is being handled on a state level. We've got the legislature in a long session. It's beginning here in just a couple of days, and there are a number of legislative concepts in existence to regulate this. They've already stopped issuing licenses with no intention of starting them again. They're dealing with this on a state level. The OLCC is the regulatory agency. Please let them do their job. They've made these requests that the legislature change the laws so that they can change the rules. and make adjustments for this statewide. I will tell you, working county by county by county, the more fragmented that this becomes, the more that every single county comes up with its own rules for cannabis that are different from the next county next to it and the next county next to us. And Clackamas, by the way, is the #3 county for licenses, behind Multnomah and behind Jackson, and #3 in producer licenses behind Jackson and Josephine. So it's not #1 in either one, to answer your question, Commissioner Savas. The truth is, this just doesn't need to be done right now. This is an issue that's being dealt with on a state level. Our U.S. Attorney General, William Williams, has put pressure on the OLCC to correct this problem, and it's being dealt with, and the more that this becomes fragmented, it's just not going to help this industry, and it's really not going to solve your problem. As a compliance individual, and as Glenn pointed out, changing the ownership structure of a single lot makes it not a tract. It divides it into 2 different tracts. Because of 280E and the structures that we have to put down to deal with federal illegality and the state legality of it, that gray area, we have to structure into multiple different holding companies and LLCs. And I know the Clackamas County has wonderful people that work at the planning department, but I promise you, they don't have the time to go through and figure out what's common ownership and not. Thank you very much.
Paul?
So Jason, just really quick, thank you for sharing. I just want to confirm, my understanding is Multnomah County has way more retail licenses, but particularly production, grow license facilities. My understanding was that Clackamas County was near the top.
Yeah, Clackamas County is #3 in grow facilities behind Jackson and Josephine.
Thank you.
Right.
That was the distinction I was trying to make, the grow specifically.
Yes.
Ken?
Quick question, do you have a bill number that's being proposed at the state level?
It's still at a legislative concept right now. They're still talking about it down in Salem. I'll be down there again tomorrow. We're hoping to get one any day now.
But at this point, there is no bill.
It's a legislative concept, as is most things prior to the session beginning.
Yep.
Okay. Go ahead.
Oh, hi. My name is Rebecca Boyle, and I live in Clackamas County. And I live across the street, probably 1,000 feet from a grow that's just starting up, or about to, someone that just purchased, and they're going to be doing a multi-license property. My concern is that there's not a lot of thought being given to all of those other agricultural uses surrounding these grows and the effect it's going to have on them by having multiple licenses. So I don't know a lot about the smell and the detrimental effect, but the little bit of research I've done is it is very fragrant, and it does affect other agricultural uses. So as a hay grower, I grow hay for people, for horses, and you know, I also have invested a lot of time and effort. We bought our own equipment, and every year we grow hay. We sell out. It gets purchased out of the field. And I will tell you that horses are very picky eaters, and how is this going to affect the hay that we grow? Are we going to still be able to sell it, or do we get grandfathered in? I mean, you know, we've been there for 20 years growing hay. So these people that are all saying, well, they've invested a lot of money and effort. Well, a lot of us that do other kinds of agricultural businesses also have. And I don't see a lot of consideration for all these other people that are being really negatively affected by it. The other thing is I'm curious how this ever became an EFU use in the first place. I mean, I don't even think these people, a lot of them are going to be using the soil. They're not using the water. They have no water rights. So why is this in an EFU area on high value land when they can grow this marijuana next to a freeway in a industrial area? I mean, this seems a commercial industrial use that you're putting on EFU land that's going to alter all these other agricultural uses in Oregon. So I feel like it is. Again, I don't have a lot of information yet. I'm just started to do my research. But I just quickly this morning looked up in Colorado, and they don't even allow commercial growing on agricultural one land in Summit County. So how many other counties in Colorado are not even growing marijuana on their high-value farmland? Does it need to be on high-value farmland? I'm curious so my question, I guess, here is...
The legislature.
So who exactly is responsible for zoning for marijuana?
Who's what?
My question is, who's responsible for designating the zoning for marijuana
The
growth?
legislature.
The legislature. So it's
Well,
the
they
one...
made it a crop.
That's the
They
problem.
made it a crop,
They made it a
even though it
crop
doesn't
like
use
your
the
hay.
soil. It doesn't use my high-value farmland soil. It doesn't use the water, but it's a crop. So I think it's a.
You'll have to call the Department of Agriculture and get
So
your
has
answer.
anybody in the county or the state called Colorado to find out how many other counties are not allowing marijuana grows on high-value farmland? That's it. That's all I.
All right, thanks. Keenan Boyle and Dylan Couture.
Could be.
My name is Keenan Boyle. I live in Clackamas County. I've been a commercial real estate broker for a little over 30 years, and in doing so, I've had to help write, read, and interpret many traffic impact studies for commercial buildings. And when somebody first showed me a design, and I'm going to specifically speak about the one on Spangler Road, that they were planning on putting 80-some-odd buildings on a 26-acre parcel, I took a look at the picture, and the first thing I said is, that's not agricultural, that's commercial, that's an industrial zone. And you got to think about the number of vehicles that come in and out of that property. You have to think about the county road. It's not designed for that much traffic, that heavy of a traffic. Specifically on my property on Spangler Road, where Spangler intersects into 213, there's a negative gradient. So as you come to 213 is about 15 feet above Spangler Road, and there's only about a 10-foot area, flat area, as you get to the stop sign. So that means anything that's over 10 feet is hanging down onto the incline, and when you let your brakes up, it actually starts rolling backwards. So this will really negatively impact if you allow this to happen, where they can have multiple sites, licenses, excuse me. And I think we really need to take a look at these and consider them as really an industrial type use and how it's going to impact the surrounding neighbors. I hear a lot of statements from both sides about employment, family, investment, hard work, payroll, so on and so forth. And I don't degrade either side's comments, but I think they pretty much negate each other. So really what we're left with is we have to look at how they impact the surrounding neighborhoods and the livelihood of people that have been there for longer, et cetera. So I support a ZDO 271. So it will limit the impact on the country roads, intersections, et cetera.
Thank you. Go ahead.
Hello. My name is Dylan Couture. I live in Eagle Creek, and I work in the cannabis community. This would also personally affect my income, my job, and I think this board should be acting in the defense of the Clackamas County citizens and in the defense of their property. And I don't see how simply just allowing more cannabis space on single tracts of land is a direct threat to other property owners. And so I think ZDA 271 would be an illegitimate use of government force against what would otherwise be innocent landowners. And I don't think cannabis farmers are any different than any other business trying to produce or sell a product, and to treat them differently doesn't make sense to me. And I have heard a lot of the other concerns, about the smell, the water use, the traffic, the buildings, and if there are legitimate instances of trespass against other property owners, I don't see why that can't be handled separately, and why a bill needs to be introduced to handle that. And so I do not support this. Thank you.
Thank you. Steve Chinello and Paul Seafort. Go ahead, Steve.
Good morning, Commissioners. It's good to be here again. My name is Steve Chinello. I reside in Beaver Creek. And thank you for your understanding for the need of ZDO 271 in order to preserve and protect our rural communities. For ZDO 271, I support only allowing one premises license per tract of land regardless of size of acreage. I do not support staff's recommendations of up to 5 licenses per tract of land. If you've had the unfortunate opportunity of having just one marijuana facility moved next to you with all the quality of life, public health, and safety issues this industry continues to bring to communities, commissioners, this is bad enough. It doesn't matter if marijuana has been classified as a farm crop. This is not farming. This is an operation of 365 days a year, 24 hours a day of activity. There is simply no relief for the surrounding community and neighbors. We need to stop allowing the industrialization of our rural lands. As a state, we continue to way overproduce marijuana for the second year in a row, with 75% of the production is going into the black market. So why do we need more than one license per tract of land? The marijuana industry continues to fail to self-regulate themselves, and they continue to be bad neighbors in their communities. I am so tired of hearing the marijuana industry complain about their huge speculative investments into this industry. Well, quite frankly, hundreds of thousands of law-abiding citizens have invested their life savings to have a little piece of heaven in rural Clackamas County and this state. And we are true stewards of the land, and that, commissioners, is priceless. In summary, as a registered voter in Clackamas County, commissioners, I urge you to please vote for one premises license per tract of land, regardless of size of acreage for ZDO 271. This is long overdue. Thank you.
Thank you. Go ahead.
My name is Paul Seifert. My wife and I live on Karis Road in Oregon City. We're full-time farmers in that area since 1980. We just hear the noise and issues, and we hear the water and the traffic, and we agree with all the above, but bottom line for us, it's just quality of life. We think enough is enough. Too much marijuana. One license per tract is what we feel. Thank you.
Thank you. Shirley Morgan and maybe, okay, so what do you think? Camrath. Last name Camrath. Go ahead.
Good morning, Commissioners. My name is Shirley Morgan with the Citizens for Public Safety, Quality Life, and Property Value. It's good to see you again, as always, and staff as well. This isn't about hemp today, but this is about industrialized marijuana production. When 60 by 100-foot cement slabs for steel buildings are poured over farmland, we've gone too far. When the odor is so overwhelming from outdoor grows and it causes allergic reactions, it becomes a public health travesty. When rural roads become industrialized freeways with semis, dump trucks, water trucks, and 1,000% increase of traffic, that's a red flag. When growers are importing dirt and dumping soil along property lines, how does that impact the soil? When these buildings are burglarized coming through neighboring properties, yes, we're concerned. Here's a look at 4 sites with the intent to tenant lease multiple licenses. 267,000 square feet with 60 buildings on 20 acres includes indoor growing and processing and hemp production. 300,000 square feet with 56 buildings on 40 acres for indoor production. 358,000 square feet with 89 buildings on 26 acres that includes processing, indoor and outdoor production, and over 74 greenhouses. 687,000 square feet with 58 buildings on 19 acres for indoor and outdoor production and over 15 buildings, 33 greenhouses, and 10 8x40 cargo containers. Multiple indoor grower licenses up to 5,000 square feet are allowed in our RRFF5, FF10, and rural residential 2-acre zones. Though more restricted in square foot size, the lots are smaller and neighboring homes are much closer, creating an even more impactful version, as many growers are already leasing to multiple growers on these sites. The marijuana industry tout their right to use their property, but neglect to note that all farmers have regulations, and marijuana is federally illegal. If neighbors don't like the smell, they say they should move, ignoring that the skunky smell infiltrates neighbors' homes. That Clackamas County has 1.2 million acres and marijuana is taking a small portion. Interesting that such a small portion is having such a big impact. We support one license per tract in the ag, forest, EFU, and timber zones, and we ask that you consider expanding to include the RRFF5, the FF10s, and the rural residential 2-acre zones. We must respect that unlimited and unregulated growth leads inevitably to a lower quality of life. Thank you.
Thank you. Go ahead.
My name is Janine Camrath, and I'm a registered voter in Clackamas County. I am speaking today in hopes of limiting the number of OLCC and OHA marijuana licenses allowed on any one tract of land. I believe that not limiting the number of licenses will allow uncontrolled access by individuals that have no respect for the farmland we in Clackamas County, and more specifically, the neighbors that live in close proximity to these proposed large marijuana grow operations, have loved and nurtured for many years. The potential damage to our ecosystem by continuous use of pesticides and chemical fertilizers used in many of these types of grow operations, and the chemicals used to process the marijuana, is tremendous. And the greater number of licensed businesses allowed on one tract of land, the more the potential damage will be. Please take into consideration that the public health is affected not only by what has been described as a skunk odor, but also by the stress that goes along with not being able to enjoy the legal right we all have to the quiet enjoyment of our own homes and yards. I support ZDO 271 that allows only one OLCC or OHA license per tract of land at site address. I have letters from 3 other neighbors that I wish to read at the same time. Is that okay?
Within that time.
Good morning, Commissioners. My name is John Kraus, and I am a registered voter in Oregon City. My wife and I have lived on Spangler Road in Oregon City and have enjoyed the safe, peaceful rural community for over 26 years. I am submitting my testimony today as I am alarmed at how quickly and quietly the approval has been given, establishing a massive marijuana growing operation at 15171 South Spangler Road in the heart of our rural community. My concerns are, I am alarmed at both the scope and scale of such an industrialized operation being established in our rural family farming community. I am extremely concerned about the known and potential unknown public health implications for our residents, livestock, and crops. It is a well-known and documented fact that the supply of marijuana in Oregon grossly exceeds the legal demand. I'm gravely concerned about the safety and well-being of our residents, given the probability of a significant escalation of criminal activity that will be created by the establishment of such a massive operation. I support ZDO 271 that allows only one OLCC or OHA license per tract of land on site. I hope and trust the commissioners consideration given here will be in the best interest of the families that have lived and cared for this community for so long. Here's another one. My name is Brady Howen. I am a registered voter in Oregon City and live about 1 mile down the road from the proposed marijuana grow operation. I'm writing today because I am alarmed with the industrialization of marijuana, which has been approved. Our community is made up of small farmers and hobby farmers. This grow operation will industrialize our neighborhood and bring pollution, noise, and nuisances that our community does not want. A big concern for our family is the level of health risk and pollution. I could go on and on. Everyone has the same concerns.
Thank you.
Thank you.
Thank you.
Scott Beck and Chris Ritter. Go ahead, Scott.
Hello, my name is Scott Beck. I'm a resident of rural Oregon City, and I'm urging you to approve stronger regulation limiting the number of marijuana grow licenses to 1 per tract of land. The current zoning ordinance allows for multiple grow licenses to operate on each parcel of EFU land. This allows for the creation of industrial park-sized development smack in the middle of farmland. EFU landowners can effectively cover their property and buildings with no limit to lot coverage. Applications for extremely large marijuana farms are occurring at an alarming rate, and the reality of living next to one of these mega grow operations is often described as a nightmare scenario where adjacent landowners' peaceful enjoyment of their land is never the same. Industrial scale development belongs on industrial zone land where infrastructure and essential services are available, not on farmland. 2 examples of the scale of development currently allowed on EFU land are illustrated on this photo board. The first at the top is an approved marijuana production facility on 26 acres in Karis. The existing farm and home has a barn and is currently planted in Christmas trees. The new landowner is proposing the construction of 88 structures totaling more than 353,000 square feet with the intent to lease to multiple growers. The second example is a marijuana production facility in the Malala area. As you can see from the photographs, the tillable soil is being converted into concrete floors with the plan of 56 barns to be leased to multiple growers. This type of development is out of place in a farming community. The impact of allowing this scale of industrial development on farmland will have continuous and long-standing effects on rural life and agriculture throughout the county, including decrease in adjacent property values. No one wants to live next door to this. Depletion of possible contamination of the aquifer, the only source of water for many families in rural areas. Road congestion and traffic safety due to the trucking of vast amounts of non-potable water and fuel, and upwards of 350 daily employees on the size of operation. A greater need for rural essential services, a decrease in air quality from the reported putrid oil or odor present, the loss of outdoor enjoyment by families in their own yards, and impact on the public's health. Allowing the industrialization of farmland is unacceptable. By limiting each tract of land to a single grower, you can minimize the negative impacts on the neighbors and the environment. Please vote in favor of ZDO 271 and help preserve the character of rural Clackamas County. Thank you.
Perfect timing. Go ahead.
Hi, my name is Chris Ritter, and I'm a registered voter in Oregon City. I've lived and worked in Clackamas County farming for 45 years and worked for Canby School District for 43 of those years. I am here today because I'm alarmed with the industrialization of marijuana approved at 15171 South Spangler Road for 358,000 square feet with 89 buildings on 26 acres that includes concentrate processing and indoor and outdoor production in over 74 greenhouses. My concern today is to address public health. My first concern is water quality. The site is not flat and will require significant grading and storm detention to control runoff toward the downhill neighbors and downstream flows. Rooftops on 88 proposed structures will also affect site drainage. Of utmost concern is protection of the aquifer from contamination by solvents used in the processing operation, potential contamination by the use of non-potable water trucked in, and removal of waste storage. Are there containment facilities required beyond the mentioned dumpster for marijuana waste? Do we know the source of the non-potable water trucked in, and if it is tested for contaminants? How will the well water usage be monitored, by whom, with what frequency, and at whose expense, to ensure that additional water is not taken from the existing well by the applicant or future owners? It may not be apparent until neighboring wells run dry. In the summer, many people have experienced the water table dropping, making wells less productive. My second concern is fire protection. Greenhouse plastic burns relatively easily, and the minimal distance between structures will make fire spread difficult to control. Processing chemicals and propane storage add to the increased risk of fire and explosion relative to other farming in the area. Uncontrolled fire could put neighboring farms and homes in jeopardy, and it seems there is an increased risk for this to occur with a processing growing operation of this size. Third, I am concerned for air quality. The applicant states that they will provide the filtration systems in the proposed processing areas, but there is no mention of filtration of air exhausting from the huge number of outdoor grow greenhouses and indoor grow ag buildings. This will likely generate significant odor toward neighbors, including Karis School, which is less than a mile away. I am concerned about the public health for the residents of this area. A marijuana growing and processing facility of this size seems better suited for an area zoned for manufacturing or light industrial, where rules are in place to oversee and prevent some of these issues. This is an industrial operation squatting on valuable farmland. I ask if you would like to live beside or across the road from this facility. I support ZDO 271 that allows only one OLCC or OHA license per tract, one site address. Thank you.
Thank you.
3 seconds.
Pretty good.
Mark Struloff and Justin Shaw. By the way, what we're doing today does not limit OLCC licenses. Right?
The proposal would only limit the number of licensed premises, and each licensed premises, depending on the tier of that license, would set a certain canopy area for that producer.
Okay. All right, go ahead.
That's bureaucratic.
Hi, my name's Mark Struloff, and I'm a resident of Clackamas County and a voter in Oregon City. I was unaware of this proposed marijuana production facility on Spangler Road until this week, so I'm coming into it a little late. I'm opposed to ZDO, or I'm in favor of ZDO 271. I'm opposed to the industrialization, the large 89 structures that are going to be placed on this valuable farmland for many reasons that have already been discussed, but the traffic, the noise, the smell, and the increased potential for crime, those are all serious issues of concern. But my main issue is that I'm opposed to marijuana totally. I always have been, and I have a very personal issue with it in the sense of I have a close family member who I won't identify, but has used marijuana continually for the last 25 years and is not able to function adequately to hold a job, to be self-sufficient. And I believe marijuana has been a contributing factor to that. So I am totally opposed to any mass production of marijuana. So again, I'm in favor of this ZDO 271 to limit as much as possible. So my hope and my prayer is what is best for our children and our grandchildren and our communities according to God's will as revealed through his written word. Thank you.
Thank you. Go ahead.
Hi, my name is Justin Shaw. I work for Heroes of the Farm. I just wanted to say that I believe in the individual rights of all people to determine the legal use of their land, especially agricultural land. Given the sometimes economic volatility of agriculture, it's imperative that farms are not further burdened by undue government interference, given the opportunity to pursue the right to use their land as they see fit and achieve economic independence through the use of that land. Furthermore, by helping farmers and all businesses in the community thrive, the benefits to the surrounding areas, including this county where these farms are located, cannot be overstated. These benefits come largely in the form of taxes, job opportunities, and the advancement of local infrastructure. I believe that these benefits of agricultural economic growth in any form outweigh the perceived potential negative effects. I also believe that as of now, marijuana is considered an agricultural crop and should not be treated any differently than any other agricultural crops. I believe that if people feel that it should not be considered an agricultural crop, then they should reach out to their state legislature representatives and voice that. That's all I have. Thank you.
Thank you. Nathan Ewing and Jeremy Menke.
Hello, I'm Nathan Ewing. I am a citizen of Clackamas County. I live in Colton, Oregon, and I work in Sandy at Heroes of the Farm. I believe that ZDO 271 is a bad policy because it limits the potential of this county to, for no reason other than just, it seems like a lot of people are opposed to marijuana, seemingly is the main reason. It affects personally through my employment. Heroes of the Farm is in a vast expanse of growth while being compliant. It seems that a lot of people here are concerned about the non-compliant businesses that are supplying the black market, which is fair to be concerned about. I mean, it affects me as a cannabis grower because it brings unfair scrutiny on the people that are within compliance. Medical marijuana growers are not converting to OLCC in vast numbers, as someone previously stated. I was a medical marijuana grower. I no longer grow for myself because of the restrictions that OLCC has placed on the medical marijuana program. And furthermore, they're not going to just, as someone previously stated, build excessive buildings outside of what their production needs are. So say they have, 100,000 square foot of canopy, which is quite immense, but they're not going to build processing facilities outside of their needs, as I guess someone stated as a concern. And that's all I really have. Thank you.
Thank you.
Hi, my name is Jeremy Menke. I've lived in Oregon for 41 years. I'm a property owner in Clackamas County and Tillamook County, and I've lived in Sandy for about the past 15 years. I oppose this because I think that from what I've heard today is a couple of bad seeds have brought a lot of people here and angered a lot of people, and I don't think that's a fair representation of this entire community. I think if there is a few bad seeds, and I've heard specific properties repeated over and over today, that those should be addressed separately and not something that's going to affect this community as a whole. A lot of these companies have already had to forfeit their licenses since inception just because of the brutal competition in this market. We've had plenty of ups and downs in this market in the past few years, and it's going to continue to do so. And during that process, a lot of this overproduction that is being brought up today is going to correct itself. Not allowing any of the businesses that have put in their hard work to be grandfathered in is a mistake. I think that everybody's gone through their due diligence to be legal up to this point, and we should be accepted moving forward as conforming property. One thing I haven't heard brought up is with these larger properties where there's a lot of different buildings, is there is a level of safety that is brought to these places, and there is also other people that help people stay compliant. So there's more eyes and there's more safety, as opposed to some of the places that are few and far between, and it's, I think they're in more danger of possibly being robbed or something along those lines. And as far as, cannabis is farming, it is farming, and it's some of the ways that we farm cannabis people might not understand, but it goes along the lines with the future of farming. We might not need soil, but going forward, we're not going to have the soil we need to produce all the food for everyone that's going to be on this planet. So a lot of the things that people don't understand about cannabis farming is the future of farming as a whole that you will probably begin to understand as time goes on. I oppose this, and I just wanted to give my input to you guys. Thank you.
Thank you. Charlie Christensen, Samuel Finn Clausen.
My name is Charlie Christensen. I live in Clackamas County. My family's owned farmland here since the 1800s. We have not much of the farm left through different inheritances. The Clackamas River has taken some. My wife's grandfather donated 10 acres to the county for Barton Park. And I don't agree with this bill. Small farmers, which is what I am now, have a hard enough time making money. I grow grass hay, and with building upkeep, fertilizer, equipment repairs, on my 25 acres of grass hay, I lose about $300 a year, counting taxes and all the other things. So I love doing hay. I know how to do it. I do a real good job of it. I've had the same customers for 25 years. But I'm looking for a way that my children can keep the farm going. I don't think grass hay is the answer. Under your proposal, we could have one licensed grow site on our 37 acres. That wouldn't be enough. If we could have 2 or 3 or 4 or 5, we could probably make some money and continue to keep the farm and the family. One of the major concerns I've heard from lots of people today is traffic. I interned last summer on a farm up in Boring, whose owner spoke earlier, Brad Troutner. And I worked out in the fields on the hemp farm portion of it, and I witnessed 20 cars a day coming into the facility. I don't think that's excessive. I know the big nursery down the street has giant semis, big flatbed trucks. They haul tractors from one site to another. Buyers coming in, interstate semi-trucks, and none of that was ever witnessed at the marijuana farm. So if you're going to regulate marijuana farms because of the traffic, I think you need to look at nurseries as well. Thank you.
Thank you. Go ahead.
Excellent points. My name is Finn Clausen. I work in the marijuana industry as well, and I'm opposed to ZDO 271 simply because it negatively affects the marijuana farmers from being profitable in an already highly regulated industry. I wanted to address the overproduction thing. Concern there, due to being not able to sell but with multiple states, we have an overproduction dilemma here in Oregon. When here in the future, when we realize that interstate commerce is a good thing and it's a benefit, then we won't have this overproduction problem. I also want to address some of the positive outcomes of being highly regulated from the OLCC. A lot of the taxes and taxation that we benefit. I'm a native Oregonian. I grew up in Oregon's public schools, and now we're finally getting the schools revamped, remodeled. Teachers are being paid more. 40% of the taxation goes to these to the taxes for education. Another 15% goes to drug and alcohol rehabilitation programs, and another 10% goes to the police department. So there's a lot of added benefits that come from all of the regulations that we face. I would say, for the overproduction problem, I would suggest an export tax that would, down the line, that would further the benefits of the taxation. The farm that I work for provides for myself and family and the ones that I love and respect, and I would like to continue to see that we can produce our cannabis and continue to be profitable in the state of Oregon here. That's all I have. Thank you.
Thank you. Linda Marino and Colin Powers. Go ahead. Time is short here.
I'm sorry. I own the property adjacent to this marijuana thing that they are proposing, and I want to lend my support to having one license per tract. They are claiming this is a farming thing of what they are doing. Well, farming does not constitute covering property with concrete. That belongs in an industrial area, not in a farming area. Our roads, Spangler Road is not a road that's going to be able to handle the traffic and everything that is going to go along with putting this marijuana farm in. And yes, I just want to say I am opposed to it, and I support that one license per tract.
Okay, thank you. Go ahead.
Thank you for having us today. My name is Colin Powers, and I've worked in the cannabis industry in many facets for over 10 years, and currently am the creative director over at Heroes of the Farm, and I support the property rights of Oregon farmers and oppose ZDO 271. These changes would take farms that have invested vast amounts of money and bent over backwards to comply with local and Oregon state laws and devalue them in the future. Devaluing these businesses is unfair to the thousands of people who have worked and sacrificed to build a successful business model in an unknown market. So I believe these conforming farms should be grandfathered in to these changes. As my colleagues have stated, the government is currently adopting many of these changes proposed here today, and the OLCC has already halted issuing licenses and is making new laws that address the overproduction. Thank you.
Thank you. Very good. Marge Stewart and Gordon Statford.
Ladies first.
Whatever. Okay. Gordon is going to do more of the speaking. And I'm a county resident and with Furwood CPO.
Never seen you before.
Huh?
I've never seen you before. Just kidding.
You weren't looking. Anyway, while some of the concerns here have been sounds very legitimate and concerning with the overuse and so forth, our local experience is totally the opposite. We see the agricultural use being extended and done right. And we say it's agricultural. Okay, isn't Clackamas County's main industry nurseries still? Well, that has, others have said it already, lots of trucks, lots of greenhouses. You know, so what's the difference? Although, like I said, some people do sound like they have legitimate concerns. And comes down to perhaps we just need to be looking at this a little bit longer and not being each county going totally separate. Now then we got to get together at the end, you know, and find a common solution. If we keep doing these things and have to change it, as we've done how many times since this whole thing started, it doesn't help the end result. Let's maybe take a little more time, look at all the different things going on, and think about it. So I guess at this point, I'm opposed to the issue at this point.
Okay, thank you.
Thank you. My name's Gordon Slatford, and I've been an Oregonian, despite my accent, for the last 28 years. I'd like to read a prepared statement from the Furwood CPO, which you have a copy of, but for the benefit of everybody else here. The Furwood CPO, located in rural Sandy within Clackamas County, is an active and involved group of local residents who take a passionate and compassionate involvement in business and residential matters within our purview. We have in the past 6 months followed with interest the growth and effect of the marijuana industry within our area and feel sufficiently informed to fulfill our role in providing advisory feedback to you. In simple terms, we feel strongly that it is the wrong time and approach to consider changes as detailed in ZDO 271, and that such changes would be damaging to cannabis businesses in our area, creating long-term impediments to growth and opportunity. We believe it is too early in the business cycle to interfere with changes to the law. To elaborate, there are multitudinal reasons to sit back and allow the fledgling industry to develop through the traditional forces of supply and demand. In particular, ZDO 271 would fly against the established principles and practices of the rights of people to determine legal usage of their farmland and agricultural infrastructure. We understand that the marijuana industry is producing 7 to 8 times the annual consumption in Oregon, and that one of two things must occur. Either production must diminish or further demand needs to occur, for example, through the medical use of marijuana extract. Within rural Clackamas County, landowners are limited by climate, topography, and existing laws. Agriculture is our primary industry, and expansion should be encouraged. This will lead to further economic growth in our county. We are fortunate to have within our boundaries one of the leading marijuana farms in the state. Heroes of the Farm has developed infrastructure, grown exponentially in the last few years, and become one of the better corporate citizens in our area. To elaborate, Heroes of the Farm have invested millions of dollars into their infrastructure and created a new economic opportunity in our area. They have grown to a payroll exceeding $600,000 per annum, which in itself, using an economic multiplier of maybe 10, is an economic impact to the greater Sandy area of some $6 million. Through their efforts, we have seen significant investment in the electrical infrastructure provided by PGE. This will allow further economic development of our rural area. Hero of the Farm are justifiably proud of their growth and the employment of so many young Oregonians. They embarked many months ago in a series of community efforts devoted to dispelling myths and rumors which abound about the cannabis industry. We with others are now educated to the technological advancements and how the industry can be highly scientific and professionally run. I will, in that case, just go to the end because you have a copy of this, and I should say it should not be the county's job to determine what industries flourish or die. However, we strongly endorse the county's role in code enforcement and encourage the efforts to improve code compliance. The Furwood CPO met on January the 8th, discussed this topic. A motion to write to the Commission stating our opposition to ZDO 271 was passed by a unanimous vote.
Okay, thank you. Janet Miller, I'm sorry I dropped yours and found it on the floor. And Eric? It just says Eric. I'm sure there's only one Eric in here. Morning.
Good morning, Commissioners. My name is Janet Miller, and I'm a registered voter in Oregon City, a lifelong native Oregonian. I'm here today. A lot of what I'm going to say has already been said, but I want to put my 2 cents in too. I'm here today because I'm concerned with the industrialization of marijuana, which has been approved at 15171 South Spangler Road. They have been approved for 358,000 square feet with 89 buildings on 26 acres. That includes concentrate processing and indoor and outdoor production in over 74 greenhouses. I'm very concerned about the industrialization of farmland, destroying the land with concrete floored buildings. I am concerned about the noise from generators and fans. I'm concerned about night lighting, especially the additional outside security lighting, even if the inside greenhouses are legally unlit from 7 p.m. to 7 a.m. I'm concerned about increased traffic, road conditions, and safety. I'm concerned about increased crime. I'm concerned about the number of people on the property 24/7. I'm concerned about our property values. Some neighbors have their life savings invested in their property. Public health is another worry. I'm worried about the water depleting surrounding property wells, both surface and groundwater runoff contamination, bringing non-potable water and runoff from that water. I am worried about the trucked-in spent soil and plant disposal. I am worried about air pollution and the smell from plants and the processing. I am worried about the pesticide use and the effects for both human and animals. Families who lived here for many years and take care of their properties to keep rural life livable and safe. We have a responsibility to care for our properties now and for the families in the future. Industrialization of rural property along with health issues are certainly not caring for our water, land, and air. This proposed project is purely for monetary gains with no regards to existing neighbors' health and their land. I quote Aldo Leopold, "A thing is right when it tends to preserve integrity, stability, and beauty of a biotic community. It is wrong when it tends otherwise." I support ZDO 271 that allows only one OLCC or OHA license per tract, one site address. Thank you.
Thank you. Go ahead.
I second that.
All right.
My grandmother owned the property right across from this proposed massive industrial marijuana complex. And I remember sitting at the porch, looking out in the evening with my grandmother, and the beautiful hills. I mean, this proposed site is on a hill, so it's visible to many neighbors. And my grandfather owned the property next to this proposed industrial complex. And I just remember looking over how beautiful the land is. And can you imagine yourself living next to an industrial complex like this? Can you imagine having to stare out your porch window at all these different buildings? This is not a small operation. And I question why it can't be put into a different area. Maybe a place that's not so visible. But there's a lot of things, as you mentioned, to take into account. And for your consideration, what about the depletion of the water table? How is that, the use of water, going to affect the neighbors in the community? What about the massive carbon footprint with all these buildings and concrete concrete foundations? Major traffic increases because it's a two-lane road. And I remember seeing cars fly over this hill on Spangler Hill, and I mean 60, 65 miles an hour, who knows, and there have been multiple accidents in that area, on those driveways. So what's going to, I mean, I think that's something you should consider, is this two-lane highway that the people travel at high speeds on. We mentioned it's an eyesore. What about the criminal activity increase? I think that needs to be taken into account. Since it's a large operation, has anyone taken into the account the possibility of a cartel or crime syndicate funding this operation? What about the light pollution if this thing runs 24 hours a day with lights generating? It's on the top of a hill. A lot of neighbors are going to see it. That should be taken into consideration. Does Oregon really need another marijuana production facility? You know, it's a multi-billion-dollar industry in Oregon, but I have heard that half of the marijuana production is going to other states.
You need to finish up. We have 6 minutes, and we have to close this hearing.
Right.
And I'd like these 4 people to have at least their word, so.
I agree. So I support one license per tract and passes ZDO 271.
Thank you.
Please.
Craig Weege and Kyle Bullock, DiCarlo. Go ahead.
Well, good morning. My name is Craig Weege, and I live in Clackamas County. I'm a registered voter, born and raised Oregonian. Been a real estate broker and own a real estate company. I've been privy to a lot of the issues that ZDO 271 has brought up. There's been a lot of good points. One thing that I don't think has been brought up is the disparaging difference, that valuation in property by identifying a certain tract as being individually licensed for one license, other tracts that are grandfathered in for many licenses. I believe that this could bring some litigious effect to Clackamas County that I really do not support. We are already taxed heavily. I mean, I live on 25 acres. I don't know if you've looked at my tax bill, but it's quite high. And the other reason is that the marijuana industry through OLCC is already quite regulated, mainly through water rights. The other thing is, if you limit licensing to just one particular license per tract, you could be also limiting the efficiency of the industry, as there are certain companies that could probably come in and assist a particular grow operation to actually be more efficient and have less of a footprint and impact in the community. So I just wanted to say, number one, I don't grow marijuana. I do have some personal friends that are pharmacists that have spent a great amount of time basically developing CBD products that are and could be very helpful to society. We have a great amount of regulation in place, and OLCC in itself has a large hand. I don't really adhere to the problem as far as the villainous negative effects of, say, security problems, as OLCC has a lot of regulations in place as far as cameras, security cameras, oversight, and whatnot. So I don't really see that as being a problem. I do see a problem with also limiting, if you have large conglomerates that have joined the industry in the early formative stages, they can, in essence, monopolize if they have multiple licenses already in place, which would, again, create a little bit of a discriminating blight on the particular issue. So no, I do not support ZDO 271, and do believe I give a very professional opinion about it. Thank you.
Okay, thank you. Go ahead.
My name is Kyle Bullock DeCarlo. I'm an OSU engineering graduate. I live in Boring with my son, who goes to East Oregon schools, and girlfriend, who is a baby nurse at Emmanuel. I have both medical license and I have a rec license, which is in the queue with the OLCC, and this could very potentially negatively impact my plans. I independently own it, and I have no other investors, and it's all on me, and I am a small farmer. As far as odor and many of the concerns I'm hearing, my own house and medical license is near a mink slaughterhouse, and I don't go down to them and challenge them and try to take away their land use or land license. Also, when it comes to pesticides, we are under such strict guidelines on pesticides. Anyone here who lives near a normal nursery is, once they're under ornamental pesticides, that they can spray anything they want. So those greenhouses are dumping anything they want on the neighboring people. What we are allowed to spray, we would fail under the current testing and therefore not be allowed to sell our product. So it's incredibly safer than anyone near a poinsettia farm, which is poisonous. Also, when it comes to water rights, we have to truck in water, in my case, or we have to go below the residential wells down to a deeper aquifer, so we actually aren't hurting anyone's water at a residential level. Groundwater, arguably, someone could say from rain went off, but that's just any normal business. Also, when it comes to zoning, everyone's concerned about traffic. I know that in the city of Sandy, they have approved a huge apartment complex, and that is going to create more traffic and more harm and more disruption with 500 new units going into Sandy and all the traffic. But I also cannot stress all the blue-collar local jobs that come from this, and much of this expansion, once it's completed, it's turned over to the public utilities. So if someone expands their power, someone between that line can now, PG can say, oh, you can have a welding shop, you can have a business. Before you couldn't, because there was no power, there was no internet, there was no infrastructure that allowed you before. No one could afford it. So many residences are benefiting, along with like the city of Estacada. They made people connect to the sewer lines, and they're improving infrastructure. So they are improving people's lives. And just like nurseries and everything else in this world, it does require trucks. And I do believe the market will solve itself and push out the less professional outfits. And the state already highly regulates this, and I cannot stress enough how many of the taxes stay local and the jobs that come with it. It is very, very localized industry, like Oregonians like. Thank you.
All right, thanks. The last two, Donald Chorus, or Grice, maybe. Jennifer Lobel, or Loeb. Let's try that. I'm terrible at name pronunciations.
Tell me about it.
Dutch, I don't even know his name. Please hurry, we do need to go, and I want everyone to have an opportunity to talk.
Thank you. So my name is Jennifer Loeb, like earlobe, and I am a resident voter and a school district employee. I actually live on Spangler Road, so I'm very concerned about a big industrial marijuana production plant showing up in our background. From a personal perspective, in my schooling, I deal with high schoolers and middle schoolers, and they have strikingly terrible results with parents on marijuana who scream and yell at them, and then they go get high, and then they come back and they're so kind. So my concern is what is spoken of is, I understand there is a use for the medical needs, but when it is so prevalent in our society, and there are so many children that we deal with at the high school who come to class stoned, and they are not 18, so why do we need more? I do not want one where I have lived my entire life. It is beautiful. We have Mount Hood, Mount St. Helens, Mount Adams. You can see all of these amazing mountains, and now there will be this ugly, disgusting, industrial example right in the middle of our beautiful soil. So if they don't need the soil, let them go somewhere else. And I noticed they live in Lake Oswego. What a beautiful thing to live in a different city than where you are going to make my home. We have vineyards. My neighbor is a vineyard. It is so beautiful. They are using the soil. They're using the sunlight. It's a beautiful example of God's creation. I honor the value and the distinct differences that we all get to choose, but the children I see on a daily basis who can't function because of marijuana, it is so disappointing. And the parents that are yelling and screaming at their children until they get high. So I respectfully support the 271 for one license. And I'm sorry I have to get to work, so bless you all.
Thank you.
Thanks.
Hi, my name is Don Grice, and I'm owner on Caris Road. My family has been in the United States since the 1500s, specifically in the Oregonian since the 1800s. And I know that time is short, so I just want to vote against the proposed marijuana growth application of any kind. And the reasons are, I had an extreme problem as a youth, which he just explained, and am over that, and am thankful for that. The local impact that it's going to have on everyone, that is already stated. I have a responsibility as an owner. I have a responsibility because I'm a concerned grandfather, and I am concerned about the things against my moral and ethical values. I oppose it being legalized also, so I am just here, again, voicing my opinion as the rights that I have. I'm concerned with my children's influence and continues with my grandchildren and the negative effects that it has, proven by myself. And with this, I'll end. Life has good lessons. Ignoring them only causes us to go over them again and again. Thank you.
All right, thank you. We'll now close the public comment portion of today's hearing and begin deliberation. And actually, I would entertain a motion at this point. You guys, the motion to extend this hearing to a date specific.
Is it February 6th?
Yes, it's right here.
February 6th was the date that we had confirmed as of yesterday.
I move we continue this matter, I move we continue this matter until Wednesday, February 6th, 2019 at 9:30 a.m. for deliberation and decision only.
Second.
Yeah.
It's been moved and seconded that we continue this matter until Wednesday, February 6th, 2019 at 9:30 a.m. for deliberation and decision only. Any further discussion? All those in favor say aye.
Aye.
Aye. Opposed? Hearing none, motion carries.
Mayor, can
Counsel.
I make one clarification? Do you have any interest in holding the record open to receive additional testimony?
I don't.
I think that's written testimony.
Appropriate. For written testimony, I would support
Written
that.
testimony.
I would like testimony.
Okay, in that case, we should set a deadline to submit the written testimony. I would suggest a week before the hearing. That would be January 30th at 5 p.m.
Okay.
Okay.
Sounds good.
That'd be fine.
All right, so written testimony needs to be submitted to be included in the record January 30th at 5 p.m.
All right, with that, we're adjourned.